there really aren't limitations on what motions can be filed in a federal case. So if you are speaking with an attorney about a federal case who cannot explain the difference to you, please speak to a different attorney. Just because the government is saying this conduct is a federal offense doesn't mean you have to simply accept that, or the counsel should accept that. Hello again, this is Lana Manitta with Rossen Law Firm, and I'm talking to you today about federal criminal motions practice. Remember to like and comment on this video and subscribe to our channel, where we present educational videos on a wide variety of topics related to criminal defense, both in the federal arena as well as the state courts of South Florida. So what are we talking about today? We're talking about federal motions. Now, within reason, because an attorney cannot file a frivolous pleading, for instance. So within that boundary, there really aren't limitations on what motions can be filed in a federal case. There are page limits in most districts and sometimes word limits, but there's not a limit to the number or the subject matter of motions that can be filed, as long as they're not frivolous, as long as you do have a sound basis in law or fact for your motion. And in fact, if a motion is not filed or an objection is not raised on a particular issue, then it's not preserved for later appeal. So it's important that if you have an issue in your case, it's got to get on the record through a motion or through an objection at the appropriate time and as fully as possible. So as we've discussed in prior videos, many motions for the defense arise from discovery review, which is once you get eyes on some of the evidence that the government thinks is relevant to the case, the ideas for suppression or exclusion or limiting the evidence might become clearer. But there are challenges that can be raised to the indictment itself, the charging document itself. And that's what I'm going to talk about today in the first of a series of videos about motions challenging the indictment. And I think the easiest way to go about it is to take a top-down approach to the indictment when determining what, if any, challenges can be made. And I mean this really literally. A federal indictment is a document, and it starts with a heading at the top of the first page where it lists United States District Court for X district, Southern District of Florida, Eastern District of Virginia, what have you. This is the first area, it's the first line, and it's the first area that you can look at to see if there's a possible challenge to either federal jurisdiction or venue. Now, the concepts of jurisdiction and venue are often confused from one another, even by attorneys. So if you are speaking with an attorney about a federal case who cannot explain the difference to you, please speak to a different attorney. I have very recently been in court and seen an attorney confuse jurisdiction and venue in an argument to the court. You don't want that to be your lawyer. Jurisdiction is really about the court's power and authority, whereas venue is about the proper forum or the location where a case is going to be heard. And jurisdiction itself has two parts. It's twofold: subject matter jurisdiction and personal jurisdiction. For purposes of today's discussion, I'm really focusing on subject matter jurisdiction. The question being specifically, does the court have the power and the authority to hear this case involving this charge or these charges? Now, for federal criminal cases, federal subject matter jurisdiction usually lies pretty simply because the offense charged is a federal crime. It's under a federal statute, or maybe it took place on federal land, okay? Venue, on the other hand, means that, it means the physical location of the court. So proper venue means, is this the appropriate physical location for this case to be tried, meaning did some portion of the offense occur here or affect this district where this particular court sits. Now, while it may seem like it's a foregone conclusion that a federal offense conveys, automatic jurisdiction to the federal court, it is still important to review very carefully the allegations that are within the indictment to see if, in fact, the government has actually alleged facts that support a charge under that federal statute. In other words, just because the government is saying this conduct is a federal offense doesn't mean you have to simply accept that, or the council should accept that. The questions that you can ask are, was it a localized offense that didn't have an effect on interstate commerce the way the government alleges it to? Is this the only district that was touched by the offense? Are there other districts? Maybe we're talking about a venue issue. Is this the best one of all to hear the case? Where did the alleged conduct take place? Did the conduct occur here in this district, but the effects were felt in another district? Where does the defendant live? Where are the witnesses located? And can a good argument be made either that a federal statute is not implicated, or venue, the location that we're in, is not the proper venue? Should the case maybe be moved to a different venue if it will benefit your client? Now, in my experience working, 26 years in a federal district known for the speed with which their docket moves very quickly and with a very high conviction rate, there's absolutely a choice that is made by the government when there are options for federal districts within which to actually pursue the prosecution. That's perfectly okay. The government can do that. Judges know they do that. But if the chosen venue, if the chosen district is extraordinarily inconvenient for defendants, for witnesses, for the transport and display of evidence, for counsel, or a variety of other reasons, there can be a chance to get that case moved. But there's more to filing a change of venue motion than simply saying, this case took place in that district. That's where the defendant was at the time. It should be tried there. Counsel really should be doing a lot of research to determine the best place for where a case should be tried. And there are tools available that an experienced federal defense attorney knows how to use. There are tools available that we here at Rossen Law Firm know how to use to gather data on not just case law, but gather data on the way that different districts, even different judges, treat different types of cases. Asking the court to change venue to a district, for example, where this type of offense is statistically sentenced higher than the district you're actually in, that wouldn't be a very wise move. So it's not just issue spotting in the indictment that's necessary for an effective motions practice, but knowing the research that needs to be done to decide whether it's actually a good motion to file. So we've just touched the tip of the iceberg on jurisdiction and venue. Keep watching for more videos on challenges to federal indictments. Remember to like and comment and subscribe to our channel, and thanks for watching.